right, I think I'm going to go ahead and get started. So I'm Derek Jensen, and welcome to our presentation today, The Life Cycle of an Estate Plan. I'm joined by my partner, Anita Shteynberg, and we are going to be reviewing and going through just some of the ideas that we look at and we think about when we're doing estate planning or starting our estate planning, or for many of you who are our clients, when we're thinking about updating plans. And I do want to remind everybody again that we are making a recording of this. Feel free to ask questions in the chat box, and we will get to those towards the end of today, or we will also be able to respond to you directly in the chat box. So as we kind of move off of the next thing we're really going to think about is how do we define the life cycle of an estate plan? What does that exactly mean to us? And where are you, or where are we at any given time in that life cycle? And I think the main point I'm trying to make with this is that estate planning is not a one and done event. It happens over time. Different events can happen in our lives at different points. There can be circumstances that change. There may require different solutions. Also, our understanding of what might be needed or what's possible could change over time also. And so we really want to think of estate planning as something that's happening really on a continual basis, and then try to understand where we're going to go with that. When we think about it in our office, one of the things I do is I think about what I think this term I call estate planning needed. How much estate planning is needed? And it's really a combination of the consultations, the meeting time, the meetings with the staff, phone calls, emails back and forth, the different information that you're going to be providing back to us, and of the strategies that we're going to be reviewing. You may have a great understanding of a lot of these strategies, or there may need to be open discussion about some of those. And that's really what estate planning is about, is kind of figuring out the right combination of meetings and consultations. And it's not just the attorney. It could be financial advisors. It could be accountants. It could be other professionals, trust companies, insurance professionals. And it could also be a family and friends who we might be calling on to be fiduciaries along the way. So there's a considerable amount of consultation that could be looked at there. Really, though, that question of the consultations is illustrated by the meetings that you're having with the attorney or the interactions with the staff in the law firm. Taylor, can you move to the next slide, please? There we go. Interactions with the staff at the law firm, input from other advisors, accountants, financials, etc., and other family members. This can also change over time, especially if we think about who we're currently working with. I had a client I was working with earlier today, and they mentioned that they're not currently working with a financial advisor, and believe at some point they might add that to their list of professionals. Well, that would be a good opportunity then to reassess how much consultation time is needed with the attorney or other professionals to get everyone on the same page. Often we'll also see family members who we might be calling upon to be a fiduciary. Maybe they're losing some of their ability to perform that role. Maybe it might be they've moved, they're no longer in the neighborhood or in the immediate area, or it could be that they have now are just not up to the task. And so understanding those tasks is important along the way too. So when we think about the estate, how much estate planning is needed, we don't only focus on the consultations, though. It's also going to be on the type of strategies that we're using. So if we're using powers of attorney, that might require fewer consultations. Those might be fairly common documents that people are used to, and so there might be a good understanding there. We might also have a pretty good understanding about basic wills or maybe living trusts, but maybe as we're adding tax planning or irrevocable trusts or LLCs or charitable planning or multi-generational planning. You know, those are going to take more, really more issues are involved with those. And so we're going to have to dive deeper into that. And that's going to cause more complicated plans and a larger amount of estate planning that'll be required for those clients. As we another point that often will come up is that we look at really what's the time horizon that we're looking at. So, for example, how urgent is the current planning? Or often we'll get clients who tell us that they are planning a trip. You know, I'm leaving on a trip for next week. Can we get anything done? Well, maybe, but we're not going to be able to get a heck of a lot done in such a short time frame. So we really want to be able to take the time that's necessary to think through the issues. And that's generally going to require, you know, a longer time horizon. We also might have clients who are thinking more multi-generational planning. They're not only thinking about, you know, their current situation or their children's current situation, but also thinking about the grandkids, for example. And that's going to require a significant amount of planning and a longer time horizon, and it'll require more complexity along the way there. One other factor that comes in is how much time can you commit to the estate planning. So again, this might be you know, say you're a new parent with a young child at home, or you're working professionals. You may not have a lot of time on your calendar for doing this work, and maybe when you are retired, you'll have more time. And so, you know, it may be worth looking back at how much planning you can do now, and see if there's some additional issues that you'd like to address at this time. So it can always change. Looking forward then, you know, what other kinds of life events could happen? There's really a significant number of events that could happen. There could be a change in your family. You've added a child, like I just mentioned, or maybe we've lost a family member. Maybe there's been a health issue that's popped up, either for yourself, for one of your beneficiaries, or for one of the people you're going to be relying on. These are all issues that could pop up along the way and require some additional planning. You could also have a change in your asset mixture. You've gotten a new job, you started a new business, inherited money from other family members. Any of these things can also make that adjustment. Or it might be that you just have more time and more goals now, or you understand the risks a little better that you are facing. And so there's additional planning that you're going to want to do and look at that time. In our office, trying to address all of these is one of the challenges that we always have. And we found that it helps if we can divide it into 3 kind of main categories. And this allows us to have the amount of consultation and strategies that we're going to be looked at more customized for our clientele. And so here in our office, we use this idea of an essential plan, which you can think of as kind of our starting plans, the plans that we're going to offer to really cover those basic documents that are going to be needed, that everyone needs. So everyone needs an essential plan. The foundation represents when we're able to do a little bit more, we have more time to invest in the process, and we're going to be now creating something we can build on and we can use even going farther into the future. And legacy is kind of a unique one. That's when we really do have that long time horizon. We're looking out to the future. We're thinking about what we can do, not only within our documents, but within the other relationships we have who are going to be involved in the implementation of the plan, family members, professionals, and the rest. And so that comes into play quite a bit there in the legacy plan, and it generally is going to require additional people, is one way to look at it. And again, I mentioned earlier how this can really change over time. So even though you might start out, you know, needing very basic documents, we may find that over time you're going to need to adjust and have something more complicated come along, or more complicated planning. And sometimes life just catches up with us, and sometimes there's just going to be something new that's happening that we need to make an adjustment. And it's not a straight, steady line. It doesn't go from, needing a very basic amount of planning now to somehow needing, quite a bit of planning when you're later in life. You can go up and down on that list. And so we do want to think of that as a dynamic, changing amount of planning that's needed, and really trying to figure out what's appropriate in any particular moment. So to kind of help with this, we're gonna start to go into a couple different examples of different types of client scenarios we might see within our estate here, and try to describe how these different situations would appear and how we would address that and what kind of planning might be needed for that. So to start with this, we're going to have really 5 examples that we're giving. One is going to be really the position of a young adult, and how their planning needs might differ and what they might be looking for. Also, starting to build a family, growing your wealth initially, what happens really at the time of when you're like me and you're an empty nester and you've sent the final child off to college, or a visionary retiree, or someone who's really looking multi-generational. So we're going to try to discuss all of these different scenarios, and maybe that can help you kind of figure out where you would line up and what type of things might be important for your situation. And so, Anita, I would like to have you take over here, and if you can you start with giving us some examples of what the challenges are in planning that's needed for those young adults?
Yes, I would love to. Hi, everyone. I'm Anita. I know I've been silent on this call, but it's nice to have so many familiar names on the call today. And for those of you who will be listening to the recording, it's great that we're able to be together and share this information. So young adults, this is an example of somebody who may not really be thinking about end of life issues. So I have a picture here. This could be your 20-something year old when you start discussing estate planning documents with them. Well, it might not be something that's top priority for them, but I find that many of my clients who are sending their kids off to college, for example, the colleges are directly asking for the healthcare power of attorney documents, the HIPAA releases. So it is top of mind of parents to make sure that they are going to be authorized to help a child if there is an emergency situation. So an 18-year-old, you know, as a parent, you don't have authorization to make decisions for your child, but it might be a good idea for your child to authorize that. And we also want to add things like the general durable power of attorney. So you can either have your child create this document and make it effective immediately upon signing. This could be appropriate if you help your adult child out with managing their affairs. Maybe they want you to handle things while they're away at college. Or maybe they're more independent and they only want you to step in and help out if there is an incapacity issue. So those are all important documents, even for an 18-year-old or a 20-something-year-old who may still be living under your roof. They might not have assets of their own, but it could be a good time to start a revocable living trust for your child. They could start building premarital assets. So we don't know what might happen along the way with their relationships, but you may consider having them set up a revocable trust for themselves. They could start building that premarital wealth on their own. Or you could consider setting a revocable inheritance trust for your child and start adding assets to that kind of trust. This is a great way to have a divorce protection without a prenuptial agreement. So prenups, you know, sometimes that can be a sticky issue, but this is a workaround as a way to build separate property for your child. And it's never too late to start if you don't have these documents already. we would love to help you prepare those. Oftentimes, hospitals and different medical organizations can help you prepare those documents for potential health issues, which is the next slide, if we could move on. Thank you. So potential health issues, this isn't an example per se of a specific scenario, but I think this is relevant for everyone. The importance of advanced healthcare directives and healthcare proxies, I cannot stress enough. We have these seminal, highly publicized cases involving very young people who were in permanent vegetative states for 8-9 years while end-of-life issues were litigated in the courts. And that's not an ideal situation. I don't think anybody wants to go through that. So why not give this kind of decision-making authority to the people you trust? Or if you already know what you want in those kinds of situations, documenting it and letting your family members know what your wishes are. I think it provides your family a ton of confidence, and it goes a long way to have these difficult conversations, but to talk about it in advance, and let those you love know what your wishes might be in those kinds of unthinkable situations. As well as protecting family members and assets during unforeseen health issues. So you want to make sure that these documents are accessible as well. Oftentimes when people are going into surgery or medical procedures, the hospitals will ask you if you have these types of documents in place. You may be able to upload it with your health records, but making sure that the medical organizations and your family members know where you're keeping these documents, so when they need them, they will be able to access them. And making and protecting family members and assets, it means that your dependents can continue to be provided for. And many times if people are incapacitated and it happens to become an end of life situation, we can make adjustments to estate plans using that general durable power of attorney. So lifetime gifts are often a power that you may give your healthcare, or you may give your financial agent, for example. We could go on to the next slide. This is building your family. So family could look different for different people. It may be that that you're getting married and you're having children. Of course, in those situations, you want to make sure that you're naming your spouse as a beneficiary and authorizing your spouse to be able to help out in situations where you may not be available, either because you're busy with the baby, traveling, or incapacitated. In those instances, you want to make sure that your spouse is authorized. And naming guardians as well as trustees for your minor children in case you are not there to take care of your child. You can have your list of preferred guardians who hopefully will be able to take over care of children if both parents are gone and the child is not yet 18. And creating trust so that any inheritance that a minor child receives will be protected and used in appropriate ways. If you don't have the typical family, you may have other beneficiaries in mind, friends, family members, maybe charities, maybe pets. In those instances, it's always, or it could be even more important to make sure you have your wishes outlined, because you're not relying on the default terms with your spouse and your own descendants. Pet trusts are possible. You can leave assets for the care of your pets, as well as instructions for how those pets should be taken care of. I think we have a few more stages, but I'll turn it over to Derek to go over the next few examples. And I just wanted to remind you all that you're free to add questions in the chat window, and we will try to address those at the end of the webinar.
Thank you, Anita. That was great. Yeah, so do remember, if there are any questions, to ask the questions. You can also email in questions if you like. So the next one that comes up that we see quite a few of is the empty nesters. And empty nesters are kind of a unique and close to my heart, because this is me as of last week. And what I find interesting about this time for clients is it's a very interesting time where we get to spend more time actually thinking about not so much the emergency. So if you will, the urgency for estate planning often when we're younger is to make sure we have something in place to take care of that immediate guardianship issue, to address, you know, what would happen as far as having trusts for minor children in place. But once we hit this, you know, very significant milestone, now we can start to think of things a little differently. We just have more time on our hands. Possibly we're a little bit more farther along in our careers. Our relationships are going to be more defined at that point. We're going to know more about where our kids' paths are going. And we're also going to likely be thinking more about what's happening with our parents also. So it's going to become a top of the mind awareness to understand about different things such as your own retirement coming down the line, healthcare issues for yourself, taxes, and the like. One of the things that we are seeing with many of our clients are fairly sizable retirement accounts. $1 million, $1.5 million is not uncommon in our practice. And these present some very unique tax planning issues. Recently, we've seen the Secure Act, which came forward in 2020, and that has been updated now a couple times, and with regulations and the like. And so some of the provisions that we've used in the past, say 5, 10 years ago or so, may need to be updated. The pathways and how to deal with that can change. When we think about our next set here would be our visionary retiree. And so for these folks, we're really going to start to imagine their own long-term care needs. They're also looking at possibly their families are pretty well aligned, and they are now also thinking possibly about charitable planning, looking to future generations and beyond, and bringing in some additional tax concerns. So here we're often concerned about the changes that are going to be happening here in 2026 for the federal estate tax exemption, where it'll be cut in half. We're also curious and watching what happens with the Washington state capital gains tax, trying to figure out how that might work in, since if you add the Washington capital gains tax, the federal capital gains tax, and the Affordable Care Act surtax, you know, we could be well above even the Washington estate tax number on its own. So we do need to make sure that our planning for taxes and the like addresses all of those different concerns. But yes, you know, looking at different types of outcomes that can come along. Now, beyond that, we tend to get into what I would consider multi-generational planning. And this adds another level of taxation to our planning, because here we're really talking about what is known as the generation skipping tax. But you know, can we keep these estates together longer in time? Can we go past just this generation? Can we go to 2 generations? Can we go to 3 generations? What would go involved in that? It may be more than just the documents itself. We may need to really look at what kind of legacy or values we're going to be maintaining here. how would we engage our family in that? So we're going to often need to engage the other family members into also being part of the planning. They will likely need to make sure they have their foundation or their essential documents in place, and they are going to also be, adding their own tax planning to keep things consistent throughout. Now, when we have business entities or anything like this, we're also going to need to consider how that will pass down. We may have heirloom property, property that we would like to keep in with the family. How exactly will that work throughout time? And so that would be another factor that we'd be looking to in this kind of planning. For family governance itself, we could actually talk about how the finances and the wealth will continue. So not just the business interests, but who among the children or the family members would be the best ones to be taking on the role of being the fiduciary for financial decisions, for the fiduciary for health decisions, and really having those folks kind of step up to the next phase. So that's if we go past that, Taylor, maybe we can look at our own journey here. So, one of the questions is really, when would I need to update? So if I've already got my planning done, why would I necessarily need to change plans? And I think the first step would be, have your goals changed? Do you want to accomplish more now? Is there something else that is going on in your life or within your family that would suggest that you should be making an adjustment or a change to your plan? If so, then it might be worth looking at the existing documents you have and trying to incorporate those changes into that. One of the features that we often use when we are starting planning is what I would used to call a risk assessment. And so it's really understanding the risks that you have, whether they are from your own capacity or possibly health issues for beneficiary or who we're naming as those fiduciaries. So have those risks changed? Is there something new that's going on in your life or your family's life or those people that would suggest that we should make this kind of an update? Also, there could be opportunities that have changed. Possibly there is maybe there's a charitable intent that we have now that we'd like to include that we didn't have that opportunity before because maybe the resources weren't sufficient to cover everything. And now we do have that opportunity. So yes, we could maybe look at those and see if there's new strategies that we could incorporate into the planning to do that. And then one of the ones we find is that maybe now we are retired and we have more time to really focus on additional planning. The larger the goals, the longer the time horizon, the more planning that's going to be necessary, and having the ability to commit extra time there is going to be important for that. So these are kind of some of the things that we would ask you to do a self-assessment on and to consider for yourself. Beyond the self-assessment, of course, we can also go and look at your existing documents. And are the existing documents really up to task? This is often where we will look at how those assets are titled. So it's very common to go into a bank or a brokerage house, or when you're filling out new forms through your employer, to be filling out the beneficiary forms or titling the account in such a way that's actually inconsistent with your estate plan. So it's worth taking the time to go back and really make a list of all those assets, look at how they're titled, look at what happens at the time of incapacity or at the time of death to those assets. Make sure that you have it consistent with your planning. So for example, it's very common to have joint tenancy with right of survivorship on an account. I know I have that on my household account. And that works perfectly well as long as my wife and I are both capable of managing that account, or even if one of us was only available to manage that account. But at some point, I'm going to want to have that full account in our living trust. That would permit an easy transition to our successor trustee, and therefore we wouldn't have a lot of anxiety about that or extra work that would be needed by our trustee at that time. It would allow the ability to consistently pay the bills and expenses. And so that's one of the things that's on my list now that I am a newly empty nester myself, is to get that account, get those accounts, last few accounts, into our living trust. In the past, we may have used beneficiary designations for a brokerage account. And again, that would be another thing in order to direct that directly into our trust so that the estate tax planning will work the way we want it to work. The estate tax planning is very efficient. However, it needs to have the assets in the trust for it to work. And so we want to make sure those are in right from the start for that purpose. So that's an example of really looking at the plan, but looking at beyond just the document itself, and looking at how the assets are actually titled.
Before we move on to the next bullet point, I wanted to add a pro tip. I don't recommend having assets listed out in your trust agreement or in your will. If you have a specific account and you want that account to go to a specific beneficiary, it's okay to have a pay on death beneficiary for the specific account. But if you're relying on your estate plan and you have your allocation for your beneficiaries, you have your asset protection for your beneficiaries, you should be using your trust agreement, either adding those assets to your trust or using your trust as a pay on death beneficiary. I suggest having an updated list of financial accounts, but keep it separate from your trust agreement or your will, meaning that it's a separate document that you maintain on your own, but you may print it out from time to time and keep it with your important documents as well, so that your survivors know which banks you use and where to find your assets.
Excellent. And so we also want to look at whether it's ready for if you are becoming incapacitated or start to lose some of your capacity. So this will happen from time to time, where really the best course of action might be to turn over the planning and the authority to someone else. So for example, it could be that there's a financial asset that might be at risk if we're starting to slow down a bit on some of our decision making. I've seen situations where, for example, just keeping track of the checkbook can be a problem. So that's a time really to use the people that you've already named within your documents, confirm that you have the right people in those roles as fiduciaries. And you may be called upon this yourself. So you may be named as a fiduciary in someone else's documents, perhaps a parent or a sibling. And if that's the case, you may need to figure out when you should step forward and help to facilitate that transition of power. And that can be a difficult conversation to have. We encourage you, though, to look into that, and it is something we're able to provide a consultation on and discuss with you, how that process would take place, how you could use a power of attorney, for example, to make health decisions or financial decisions, or how you could take over as a successor trustee if you're named as a successor trustee. So that's one of the things we would see there. Of course, the other type of transition that happens is at the time of death. And at that point, that's kind of the end of your plan, but it might be the beginning of, really the next plan, the assets moving on to the next generation. And that's something that I think would be worth talking about, Anita.
So after death, estate planning stops. Your documents are irrevocable. So the revocable living trust becomes an irrevocable trust. You cannot change your estate plan from the grave, but it's an estate administration matter. And hopefully the people you have assigned to the fiduciary roles are capable and willing to carry out your instructions. They would be free to hire us to help administer the estate for the trust administration matter. Sometimes people try to do it themselves, or they're free to hire their own, selection of attorneys that may be available.
Excellent. Thank you for that. So when should you modify the plan? So we've tried then to suggest that you go back and you look at your documents. It does make sense to look at them every once in a while. If you haven't reviewed your documents lately, I recommend that you do that maybe right after today, maybe do it right after dinner tonight. Go ahead and get them out and review those and look over them. But you should do it every 3 to 5 years. And that doesn't necessarily have to be, with us in our office. But if you do see something that comes along within those when you're looking at it, yeah, you're welcome to come in or schedule a time to come into the office to do that. The more common things that we think about is and these might actually be more of an urgent adjustment is needed, would be if there's been a major change in your life. And so it could be a health issue. Again, it could be something with one of your fiduciaries or one of your beneficiaries that might require you to come in and make some adjustments or some changes. Or there's been changes in your assets, that make it require a change. As a tax guy, I tend to think of, those the estate becoming larger and kind of going over those exemptions. Currently about $2.2 million for Washington state, and it will be coming back down to about $6.5 million per person for the federal government in 2026. So we're keeping those numbers in line and in our mind as we're looking at how we're going to be doing our planning going forward here. And so, Anita, do you have anything to add to those? When maybe a pointer on another great time to do it?
So my clients often ask me what happens if you move to a different state. Are your documents still good to go in the new state? I usually suggest having somebody in the new state look over your documents. There may be necessary changes because every state has their own rules. Would you add anything to that answer, Derek?
Oh, that's a great answer. No, that's exactly right. We also get that question quite a bit from in the other direction. So we have people who move into Washington and now they would like us to review the documents. One of the great things about using a living trust is it is a portable document, meaning you can go from state to state. Any U.S. jurisdiction, it will work. But it does make sense to look and see if the particular state you're living in has any unique provisions, tax provisions, or other customs or rules that are being used. Washington does have a modern trust law. We've updated our trust law. There's one of the more modern uniform laws in the country, and so those are come in and can be very helpful here when folks move here. So yeah, those are great. That's a great point, Anita. Thank you very much. So without that, I think we have some time for questions. So we did a pretty good job rushing through here. Hopefully we didn't rush you too fast through it. I see one of the questions we have here, Anita, is really talking a little bit more about trusts. And I think it was the point you made about how having a living trust and using that as part of your plan can also help to replace the need for a child to have a prenuptial agreement. Could you maybe elaborate on that a little bit?
Sure. So this could mean different things. It could be that your child is setting up a revocable living trust for themselves and putting their own earnings in this revocable trust. And these are premarital assets that they could keep separate during any times that they are married. And they could, accumulate or appreciate in value, but these could be set aside as premarital separate property without the use of a formal prenuptial agreement. It could mean that a parent is setting up a revocable trust for their child's inheritance. And if you wanted to leave it flexible, you didn't want to transfer that money to your child in advance during your lifetime. It might be a revocable inheritance trust. It's still, it's a grantor trust as to your own assets, and but you're setting up this fund for your child, and it would be clear that that not only is it an inheritance, which is separate property, but it can easily be maintained separately from the spouse.
Yeah, and I will just step in here a little bit too. I don't know if it completely replaces the need for a prenuptial agreement. I mean, really, a married couple, as they're entering into marriage, should consider how they wish to treat their property and whether they wish to have it separate in community. And anyone who's entering into marriage in a community property state should have an understanding of how community property works. But yes, Anita is exactly right. When you have your separate property before marriage, if you keep that segregated in a trust, or if you inherit money and it's segregated enough to the side, it will be separate property, and that can very much help in the event of a divorce. And that is one of the planning strategies that we do like to encourage. So we do have a question here about if we are licensed in any other states. We are not licensed in other states. However, we do have a number of colleagues from around the country that we work with closely with clients in those states. And we have also a referral list of attorneys in really across in any jurisdiction, any community. There's probably 3,000 or 4,000 names on there, and we could find somebody to assist you in those other jurisdictions, or a relative. We'd be happy to do that. You can just get in touch with us and tell us where you're looking to go, and we'd be happy to help you find some help there. Oh, okay, let's see. This one is definitely for me. The recent IRS irrevocable trust changes and effects on estate planning. Yes, so this was an article that popped up in the New York Times here not too long ago, and it had to do with the question of whether you could obtain a step up in basis on an irrevocable grantor trust. I actually wrote an article on this, and I think we presented it in one of our monthly newsletters here. It may also be on the website. This was not really a surprise to me as a tax planning attorney. This is the way I've been approaching it, quite frankly. And the concept is that if it's excluded from your estate for estate planning or for estate tax purposes, then it's also excluded from the benefit of being in your estate at your death in order to get that 1014 fair market value basis adjustment. That makes perfect sense and it's consistent. There were a few attorneys and commentators who had looked at the specific provisions in the code and had argued that there was essentially a loophole that was big enough to drive your Mack truck through, so to speak, in order to have your value inside that trust excluded from your estate for estate tax purposes, but still eligible to receive a step up in basis. And so all the ruling from the IRS did was tell us, well, no, that's not really the way that works. It works the more common sense way, which is the way that we've approached it. You can still use irrevocable, an irrevocable grantor trust and have it included in your estate for income tax purposes. However, it will be excluded from your estate for federal estate tax purposes, and it will also be excluded from your estate for step up in basis purposes. There are ways to have it included in your estate or included in your spouse's estate or the estate of a beneficiary. And there's other ways that we can plan around that basis adjustment if needed. For example, we can grant a special limited power of appointment over portions of that trust that are going to be would benefit from that step up in basis, and we can go ahead and bring that on in there. That's not a common provision, but you would need to do that possibly in a state where you don't have the state estate tax like Washington State. Okay, can you go over more what a living trust is for a childless person, what the living trust would be used for? Is this the same as a revocable trust? Yes, so one of the early uses I had of a revocable living trust, where I really found it useful, was for those folks here in Seattle. If you recall, a number of years ago, there was an article called "Childless in Seattle," and so this is a large portion of our clientele, I think. And if you think about it, estate planning really is very traditional. It's very much the Ozzie and Harriet type of planning with the kids. And you're relying often on those fiduciaries that you know who are blood related, who are your children, to make all these decisions at some point. But that's not all of us. And if we back up from that, we can think about, the bigger issue usually for these folks is not going to be transferring the wealth down to the next generation, or even making those gifts. What they're really going to be wanting to make sure is that their planning or their wishes are followed out in a period of incapacity. So we call this a care management trust. It's a variation of a living trust. It just adds additional provisions really into the distribution of the trust that address how would we determine if you're incapacitated, and then address really how your assets should be used to provide for your care. It's ideally suited if you're going to be using a professional trust company, for example, to make these decisions for you, or one of the great fiduciary companies we have here in the greater Seattle area, or if you're going to be relying on a family member or a friend who may not be as familiar with what your wishes are. And so this is one of the tools we definitely would use there. Let's see, Anita, can you see what our next question is on that list?
Yes, the next question is, as we retire and think about possibly moving into a different state for establishing residency, is there a look back period Washington has for taxes? My understanding is that Washington estate tax can apply to anybody who is domiciled here in Washington state at the time of their death, or still owns real estate here in Washington, which means that that real estate itself is taxable in the state of Washington. Domicile is defined by the Washington State Department of Revenue, and it includes a number of factors. So they're trying to establish where your permanent home is. Some of the factors might be the address where you report your federal income tax return. It might be where you're registered to vote. It could be how long you're living in a certain residence, so length of residency. Social ties or business ties could be a factor as well. So it's not necessarily how long you've lived somewhere, but it is using all those factors to determine your domicile. So I wouldn't say there's a look back period per se. It depends where your permanent home is.
Okay, so let me kind of go through this one. I'm going to try to, might have to embellish this a little bit to see if I completely understand the question here. I think it's two parts. Could you briefly describe the tax consequences of distributions in an irrevocable trust to beneficiaries if it was set up as a generation skipping instrument for passing a grandparent's contributions to grandchildren's? So on this, yeah, there isn't an estate or gift tax issue there. That's already going to be addressed when the contribution was made by the grandparents. I think what we're looking at here is really the actual distributions, ordinary income possibly, that's coming out of that trust. And so within a trust, you can have a simple trust, You can have a complex trust. And the important thing to kind of realize about income taxation on a trust is that they do have the same tax rates that we have as individuals. It's just that the bracket is severely compressed, so that by the time you're up around $10,000, $11,000, $12,000 worth of income inside that trust, you're going to be at the highest ordinary income tax brackets. And so generally we want to have a very tax efficient investment strategy inside there, but we will eventually have income that's earning inside of that trust. And one way to address that is to actually make distributions out to the beneficiaries. So as a distribution is made from the trust to the beneficiary, it's going to carry with it a portion of that taxable income. This can be a very useful tool if the beneficiaries, for example, the grandchildren, are in lower tax brackets. This will appear on their income tax returns, and depending on their, what their return looks like, they're going to be maybe in a zero, maybe a lower 5, 10, 15%, something down in here as far as their, effective tax rate. And so that could overall reduce the amount of taxes on those assets considerably. The second part of this question says, prior to the death of a child, who can take a distributions approved by the trustee? So on this one, I'm not exactly sure what that means. I think it just means if it could be that the trust was in fact, the child was also a beneficiary, and you might have the child and the grandchildren all as beneficiaries of the trust. And this can be effective in that we can, pick and choose sometimes, depending on the language in the trust, on which beneficiaries we're going to make distributions out to. So I don't know if I got that question exactly right. If you do have, can provide a little bit more guidance on that, I'll try to address that offline here after the meeting. The last question I see here on our list, unless any more have come in, Taylor, would be, would you please explain the two alternatives, step up in basis at death or valued at the value when placed in the irrevocable trust? Okay. Yeah, great. So we have carryover basis when you make a gift. So if you make a gift to someone during your life of a capital appreciated asset, they will take the basis you have in that asset. So for example, if we made a gift of stock that had, $10,000 worth of gain in it, and the stock was then sold by the beneficiary, they would be paying taxes on the $10,000 of gain, but they would be paying it in their tax brackets. The alternative would be if they receive it as an inheritance. And so this would, again, kind of going back to our earlier question, if that asset is included in their estate for estate tax purposes, then under Code Section 1014, we're entitled to a fair market value basis adjustment. So we look at what the value of it is right now. It could then be sold by the beneficiary or the person receiving that gift without any capital gains tax. And this can be a very, it's a very significant. A lot of folks will own real estate that's appreciated significantly. And so including it in their estate and getting that step up in basis can be very valuable. So yes, those are the two alternatives. One would be making a gift. You're going to get carryover basis. It's the normal approach. And the step up in basis, that's only available if you make that gift happen at the time of your death. So. Let's see. Question here. I thought a living trust could help to avoid probate, which could be helpful for speed and ease. This is true. We do need to have the assets in the trust. So the two ways you have assets going into the trust are, well, there's three ways really. The first one might be that we've gone ahead and titled that asset like real estate in the name of the trust. The second is that we've named the trust as a beneficiary. You could even do this on, an account, a brokerage account, or an inheritance or a retirement account. The third way that things get into the trust, however, is through the will. We often think of the will as a pour over will. And so that pour over will would direct it back into into the trust, and that would require a probate if you're over the exemption amount, or excuse me, the $100,000 real property portions of that. So yeah, we just want to confirm that those assets are actually held in the trust directly, or they're directed to the trust. So this is going back to the irrevocable generation skipping trust. I think this was the follow-up question on that. So the irrevocable trust protects against federal death tax, yes, because the property goes into that trust. And it would be protected against the estate tax at the death of the child, for example, but are taxable as regular income per the K1. Well, it's two different questions. So the value, the asset, the principal, if you will, is the one we're looking at for whether there's an estate tax. The eventual distribution out of there, a portion of that might be ordinary income. So in the example, if there was $10,000 of ordinary income and we're having to pay income taxes in the irrevocable trust, income taxes still have to be paid. But if that is then distributed out to the beneficiary, it would be paid on their income tax return. If the trust ended and the say $100,000 that generated that $10,000 of income was paid out, no, there's no income tax on that. That just gets paid out directly. So that's all the questions we have. And thank you all for joining us today. We do have another webinar coming up in November, specifically on funding your trust. And we will be trying to do one of these each quarter, so do look out for that. And we appreciate everyone's attendance today. And if you do have any other questions, please feel free to send an email into Anita or myself or the staff here, and we'll get back to you.
And don't forget to sign up for the monthly newsletter. We'll try to keep you updated on any important changes in the law, tax updates, those types of things.
Great.
I think the link is in the chat as well to sign up.
Excellent. Yeah, we'll go ahead and leave this open so you can check the chat to get that. And appreciate everyone stopping by today.